Thank you for that generous introduction, and thanks to the Humanities Forum for having me here today. It's a great pleasure to get to speak to all of you, and I look forward to hearing your thoughts and questions afterwards. What sort of proof persuades? What kinds of evidence are deemed credible, worthy of trust and belief? These questions cross disciplines, methodologies, and historical periods. They confront the historian reconstructing the past, the scientist designing an experiment, the theologian evaluating the justifications for religious faith, and the lawyer marshaling evidence for a case. They are questions partly rhetorical and partly epistemological. They force us to ask both what methods of presentation and representation convey knowledge effectively, and even more fundamentally, what counts as knowledge at all. These questions arise with particular urgency in the courtroom. Legal judgments require the weighing and evaluating of evidence, decisions about whom and what to believe. Persuasion, conviction, is a matter of both head and heart. One may be convinced by logic, but feeling persuaded is also just that, a feeling. What then makes an evidentiary claim convincing, and how do ideas about what makes an evidentiary claim convincing change over time? I'm presently working on a book that takes up these questions by focusing on the rise of visual and expert evidence in the American courtroom and the connections between them. In the book project, I trace the gradual rise and ambivalent reception of two categories of proof: visual evidence, from diagrams to photographs to films and computer animations and simulations, and expert evidence, particularly expert evidence of identity and evidence that purports to reveal the inner state of the human body, such as fingerprints, handwriting identification evidence, X-rays, serology, ballistics evidence, the polygraph, and DNA. I look at visual evidence, expert evidence, and their intersection, for one of the central purposes is precisely to trace the areas of overlap between the two. Today, what I'm going to do is give some general background on how expert evidence was understood in the late 19th century, and then spend some more time on one particular case study, the rise of the X-ray as legal evidence. In this case study, we shall see both how experts deployed visual images to shore up their own claims to authority, and how they struggled to rein in the image, to make it footman rather than master, to claim the continued primacy of their expertise and their interpretations. In the final decades of the 19th century, as a result of both legal doctrinal shifts and cultural transformation, there came to be a growing suspicion of eyewitness testimony as a means of proof, and an increasing, although deeply ambivalent faith in the higher persuasive value of those forms of evidence that seem to be able to make nature speak directly. Expert evidence, visual evidence, and the evidence produced by technological instruments like microscopes, X-ray machines, and cameras. Each of these offered a mode of proof that was apparently less dependent on the vagaries of human memory, powers of observation, or moral integrity. Visual evidence turned jurors themselves into a kind of virtual witness. Scientific evidence claimed that careful application of method could lead to a privileged knowledge of the natural world, and technological evidence offered the objectivity of instruments, seemingly untainted by the dangers of human subjectivity. I call these forms of proof together ostensive evidence because of the ways in which they purported to be self-evidently true. Ostensive evidence claimed to be believable because of its privileged access to reality, rather than because of the personal credibility of the speaker. Ostensive evidence became more important in the late 19th century in two different senses, both empirically and conceptually. Visual evidence and expert evidence grew to be used ever more routinely. They simply became more common, more frequently deployed weapons in the lawyer's arsenal of proof. Simultaneously, they also became more important evidentiary categories. They grew to be the subject of analysis and debate, viewed as not only worth using, but worth analyzing. Not only worth analyzing, but worth contesting. Although ostensive evidence was certainly neither named nor understood as a coherent category at the time about which I'm speaking, And in this sense, my category is self-consciously ahistorical. That is, it's not a term that the participants would have used. I do think that these forms of proof, which I'm labeling ostensive, came to be seen as superior to lay eyewitness testimony. It came to be believed that, at least in theory, the evidence of nature ought to trump the evidence of man. But this growing reliance on ostensive proof was also challenged and contested in significant ways. In actual practice, ostensive evidence only very rarely provided what one turn-of-the-century legal commentator hoped for, and I'm quoting, "The awful force of the blow to the guilty man when he first beholds the evidence of his crime illumined by the light of the scientific test." More often than not, ostensive evidence in practice failed to live up to its promise. Consider, for example, the rise of the expert scientific witness. Today, the expert witness in court is a familiar figure. And even now, there is, I think, a deep ambivalence about the use of expert knowledge in the legal system. On the one hand, it is seen as necessary and helpful, and quite possibly superior to other forms of fallible proof, such as, for example, the lay eyewitness. But at the same time, experts are seen as potentially unreliable, even dangerous. In the words of one evidence law scholar, mercenaries, prostitutes, hired guns, witnesses devoid of principle who sell their opinions to the highest bidder. Occasionally, that experts may be for hire becomes explicit. Consider the pearls of wisdom emanating from the mouth of a testifying witness in a 1954 torts case. Question: is that your conclusion, that the man is a malingerer? Answer: I wouldn't be testifying if I didn't think so, unless I was on the other side, and then it would be post-traumatic condition. While certain forms of expert knowledge have been used in the Anglo-American courtroom for centuries, the modern idea of the scientific expert witness, called by one party to a lawsuit and permitted to tell the court and jury his or her opinion, is very much a creature of the 19th century. In fact, the use of the word expert as a noun is a 19th century invention, and the Supreme Court of the United States used the term expert witness for the first time in a case in 1851. By the end of the century, the Supreme Court had discussed expert witnesses and expert evidence in 118 cases, 102 of which took place in 1870 or later. Interestingly, the party-controlled expert witness was widely criticized just about from the moment of its birth. As one lawyer wrote in 1899, the testimony of experts is the subject of everybody's sneer and the object of everybody's derision. It has become a newspaper jest. The public has no confidence in expert testimony. Perhaps the most frequent criticism of experts was their partisanship, the way that they too often were the hired mouthpiece for a party's point of view. Even experts themselves recognized that undue partisanship was a frequent and lamentable occurrence. As one doctor wrote, the facts that experts were paid, often handsomely, by the party that called them, led to, quote, an array of experts swearing for their respective clients with an unction and vehemence born of desperation. Numerous articles around the turn of the century implored in vain for expert witnesses to strive to imitate the impartiality of a judge, not the passion of an attorney. Expert testimony was also attacked for being irreconcilable and contradictory. Too often, courtroom attendees were entertained by the sad spectacle of two sets of experts giving solemn testimony in direct contradiction to one another. As one legal journal groused in 1872, the summoning of expert witness by plaintiff and defendant, like the collision of opposing rays of light, ends only in darkness. Commentators did recognize that there could be serious and legitimate disagreement between competent experts. As one judge allowed in a speech before New Hampshire's Medical Association in 1897, yes, it is a visible truth that doctors as well as lawyers and ministers of the gospel do disagree. It would be marvelous and deplorable if they did not. If there were no disagreement, investigation and experiment would cease. But even if disagreement might sometimes reflect good faith pursuit of science, rather than partisanship or charlatanism, it was nonetheless understood as a serious obstacle to effective and rational jury decision-making. Juries heard expert testimony precisely when they lacked relevant knowledge for themselves. How then could they possibly make sense of contradictory expert testimony when by definition they lacked sufficient knowledge of the matter? It was, as Learned Hand put it in an influential 1901 article, quote, setting the jury to decide when doctors disagree. The whole object of the expert is to tell the jury not facts, but general truths derived from specialized experience. But how can the jury judge between two statements each founded upon an experience confessedly foreign in kind to their own? It is just because they are incompetent for such a task that the expert is necessary at all, wrote Hand. Thus, in the closing decades of the 19th century and the early part of the 20th, nearly everyone who came into contact with the use of experts in the adversarial courtroom was dissatisfied. Critics blasted liars, damn liars, and experts, and frustrated judges sometimes instructed juries that expert evidence, though admissible, was properly understood as the lowest order of proof. But it's critical to understand that this widespread frustration stemmed more from disappointment than hostility. Expert evidence was routinely condemned in practice precisely because it failed to live up to the ideal expected of it. It was thought that ostensive forms of proof should have been able to provide objective, authoritative evidence, better than that of mere fallible lay eyewitnesses, and instead, the spectacle of warring witnesses became its signature. Thus, the late 19th century is marked by a fundamental ambivalence, an anxiety about the practical and institutional limitations of scientific evidence, coexisting uneasily with a belief in its tremendous potential and promise. With this background in mind, I turn now to one case study in ostensive evidence, the rise of the X-ray as legal proof. Though evidentiary acceptance is sometimes thought of as a slow process, the conventional wisdom is that law lags behind other fields, preferring caution to overeager adoption. The X-ray was used in court less than 1 year after its invention. In fact, X-rays were used in court well before they were even generally understood or their limits well articulated. Wilhelm Röntgen announced the discovery of what came to be known as the X-ray at the very end of 1895. Less than a year after this announcement, X-ray evidence had made its way into the courtroom in England, France, Canada, and the United States. The earliest legal use took place in Montreal, in a criminal case, just 2 months after Röntgen's discovery. A barroom argument led to a shooting. An X-ray helped a physician locate and remove the bullet from the victim's leg, and the victim brought both the bullet and the image to court. Just 2 months later, in Nottingham, England, in March of 1896, X-rays again became legal proof. Miss Folliot, a burlesque dancer, had fallen through a dilapidated stairway in a theater. She sued and submitted X-rays of her leg to prove her injuries. A number of English and American journals, both medical journals and legal journals, noted this case, calling it, erroneously, an evidentiary first. And many of the commentaries welcomed the new technique into the courtroom. As one British medical newspaper wrote, those medical men who are accustomed to dealing with accident claims, and such claims are now very numerous, will perceive how great a service the new photography may render to truth and right in difficult and doubtful cases. If the whole osseous system, including the spine, can be portrayed distinctly on the negative, much shameful perjury on the part of a certain class of claimants, and many discreditable contradictions among medical experts will be avoided. This case is a distinct triumph for science and shows how plain fact is now furnished with a novel and successful means of vindicating itself with unerring certainty against opponents of every class. Even in this early report, we can see two of the significant tropes present in many of the early discussions of X-rays as legal evidence. First, it was seen to offer unerring certainty. It was thought of as authoritative, the product of a scientific and hence trustworthy process. The early confidence in the X-ray image is especially striking, given that the cause and nature of X-rays were still quite mysterious. The X in X-ray was due to the unknown source of the phenomenon. But even if not yet fully understood, the new process was deemed not only credible, but conclusive. In a typical remark, one physician wrote in a legal journal, "There are no errors in X-ray photography. There are errors of our own or false interpretations, but the X-rays do not lie." Like the photograph before it, the X-ray was often understood within a register of objectivity. It was seen to be a replication, a product of nature itself, an authoritative depiction. It offered the lure of mechanical objectivity, seeming to trace directly that which could not be seen without its aid. One of the dilemmas of expert testimony was that experts offered opinions, and they were often contradictory. And X-rays, it was believed, could transcend these contradictions and replace shameful disagreement with plain fact. Note, too, how the X-ray was portrayed as a great boon to honest physicians. It was said that it would prevent perjury and aid the party that had truth and right on its side. As an editorial in an early leading X-ray journal put it, quote, "A surgeon furnished with a radiograph of a fracture would be well armed against the ill content placed in a patient's mind, and would, we believe, be saved from any imputations on his skill." X-rays were thought to offer physicians concrete protection against malingerers and fakers who misrepresented their harms and injuries. Surgeons and physicians were especially drawn to the X-ray because it seemed to speak directly to the fact finder in a seemingly unmediated or at least neutral way. An embattled expert could point to an X-ray to corroborate his claims. This use of X-rays to buttress the physician's authority is an example of a more general phenomenon, the use of visual displays by experts to shore up their own opinions. Instruments and measurements with which to measure, record, and provide visual substantiation of their claims to knowledge, what sociologist of science Bruno Latour has termed inscription devices, provided a means for experts to gesture to their own intimate connection to nature and a way to locate their evidence in the silent authority of objects. Now, the X-ray was an enormously popular sensation almost from the moment of its discovery, as earlier newspaper accounts celebrated it as uncanny and astonishing. And most judges quickly chose to permit it rather than to exclude a new visual technology that, in the words of one historian of the X-ray, triggered a craze unlike any that had come before. There were soon X-ray slot machines, where you could see your own bones or other people's just by inserting a coin. X-rays boys clubs, X-ray studios, where the curious could go get pictures of their own bones. X-ray cartoons in popular journals. X-ray demonstrations at Bloomingdale's, even a spooky X-ray exhibit in a darkened room at an electrical exhibition in New York City's Grand Central Palace. In this climate, it's not altogether surprising that judges, too, jumped onto the X-ray bandwagon in order to show that law would not be a laggard. However, this almost immediate acceptance of X-rays as legal evidence had some ironic consequences. Some of the earliest cases reveal how poorly X-ray process and technique were understood, even as the images were being admitted into evidence as the latest instantiation of the miracles of scientific progress. For example, in 1900 in Massachusetts, Alfred DeForge, a railroad freight brakeman, sued his employer after his left foot was allegedly injured in an accident. His treating physician testified that the foot was very swollen, his ankle was black and blue, but there was no protrusion of any bones through the skin. The physician was positive that there had been a dislocation, but merely through visual inspection, the doctor couldn't determine whether or not there was a fracture. But a set of 2 X-rays of the foot, taken by another physician and developed by a photographer, convinced this doctor that DeForge indeed had a fracture. The plates revealed an enlargement of the bone on one of his feet, and this, said the physician, was the result of a fracture on the inside of the bone. As a result, the doctor said the man would always have a weak foot and would never again be able to perform the duties of a freight brakeman. If it had only been a dislocation, the physician said the foot might have healed completely. And the physician further acknowledged that the only reason he knew it was a fracture rather than a dislocation was thanks to the X-ray image. And so the X-rays were introduced in court. There were 2 plates. One had left marked on it in lead pencil, and the other said right. It was the plate marked left that revealed the bone enlargement that the physician diagnosed as a fracture. But the defendant claimed that the enlargement on that foot was actually nothing more than a congenital anomaly that didn't affect his use of the patient's use of the foot at all, and that in fact, the enlarged bone was on the healthy foot rather than the wounded one. His expert witness, an experienced physician and surgeon with a real interest in X-rays, testified that the plaintiff's image was being read backwards by interpreters who didn't know what they were doing. that the plate marked right was actually the left foot and vice versa. He tried to introduce his own copies of the x-rays, made from the same plate, but the trial judge excluded this evidence. He tried to explain that in printing the x-rays, the feet would be reversed if it had been done in the ordinary way, but the court would not let him introduce the negatives into evidence either. The photographer who developed the x-ray was recalled to the stand, and he acknowledged, "I don't know much about the x-ray." He eventually admitted that despite the markings on the x-ray plates, he really didn't know for sure which image was the left foot and which one the right. The jury nonetheless found for the plaintiff, and the defendant appealed and did win, largely on the grounds that the negatives of the x-ray and the other plates, also marked right and left but the other way around, had been unfairly excluded from evidence. Now, the issue in this case went not to the arcana of x-ray interpretation, but simply to the basic mechanisms of x-ray production. And yet some judges were willing to allow the x-ray into evidence, even though it was far from clear that those who made them knew enough to inspire much confidence. Notwithstanding the celebratory tone of some of the earliest accounts of x-rays in court, physicians quickly began to realize that as legal evidence, this new technique posed some difficulties for them. Rather than simply ferreting out charlatans and malingerers feigning injury, within the first decade following Röntgen's invention, x-ray evidence was used in many malpractice cases involving fractures, and as well as malpractice cases based on injuries and burns alleged to be caused by the x-rays themselves. In fact, malpractice cases soon constituted the bulk of the early x-ray cases, and plaintiffs claimed that either they'd been misdiagnosed or that their early treatment had not been as successful as it should have been, and it was the plaintiffs often using x-rays as proof. Thus, doctors came to realize that the new light, as it was known, could be aimed against them. By the turn of the century, some physicians were recognized, as one put it in a speech before a medical legal society, that although the use of x-ray is of inestimable value to us in making diagnoses, it is not an unmixed personal good. If it increases our diagnostic ability, it also increases our responsibilities, and we are more exposed to suits for malpractice and fractures, particularly if deformity exists. Negligence will be claimed for failure to use it in all cases where bad results follow. We thus see an early example of defensive medicine. As early as 1901, one doctor urged surgeons to take x-rays in every doubtful case, for otherwise the patient might have one taken on his own initiative, and much trouble might result thereby. Physicians worried that if they didn't take an x-ray, they'd be found negligent if the patient didn't recover. And this was not an unreasonable fear. The required standard of care in medical malpractice cases is not fixed. It depends on reasonable practice and custom within a given community. A surgeon must treat the injuries employed to treat with ordinary diligence and skill. He need not provide a cure, but he needs to provide reasonable care. He needs to behave in a way that would have been considered reasonable and diligent by other experts. Therefore, once an x-ray did become part of the ordinary way to diagnose fractures, a failure to use an x-ray in diagnosis could be grounds for liability. Their own acceptance of the technique could generate a legal obligation to use it. Though the concerns of the physicians around the turn of the century in this regard were a little bit premature, by the 1920s the cases do reveal exactly that dynamic. In addition, and I think more interestingly, physicians began to fear that the x-ray would actually change the standard of care in fracture cases. They worried that the x-ray would alter the expectations for what counted as an adequate treatment and cure. Previously, a fracture was deemed cured if the patient had use of it. But in the first decade of the 20th century, physicians began to worry that plaintiffs would claim that curing a fracture meant that the bones should be aligned on a subsequent x-ray. They worried that plaintiffs would persuade a judge and jury that if the x-ray didn't illustrate a perfect union of the bones, this lack of alignment would indicate the physician's negligence. Now, one could argue that such a change in standards would reflect a well-functioning legal system. That is, a new technology improving the quality of care and the appropriate standard of care expected from doctors, therefore improving too. But that progress story is a little too simplistic, for the change in standard from function to alignment is itself less practical than aesthetic. A limb might be perfectly functional and nonetheless appear imperfectly aligned in an x-ray. Moreover, the aesthetics of limb alignment are not like, say, the aesthetics of external scar tissue. Whether limbs are aligned or not is invisible, indeed unknowable, unless one has access to the X-ray. As one physician complained, the actual reading of the X-ray picture may be and is in many cases easy. But in charges of malpractice, it is not the beauty of bone scar that should determine the rights of the case, but this is the thing that is being ingeniously waved before the eyes of juries. It should be the relationship, if any, that the skiographic appearances bear to the clinical results produced by the treatment. Now, in fact, there was not a wholesale shift from an expectation of reasonable function to an expectation of alignment, but the rise of the X-ray did make an alignment one possible indicator of whether or not a surgeon had used adequate care. That bones were still out of alignment post-treatment was never said to constitute negligence per se, or negligence as a matter of law. But by the early 1930s, there were cases in which a lack of alignment, with very little other supporting evidence, was deemed sufficient to support a determination by the jury for a plaintiff. In a 1934 case, for example, a 9-year-old girl fell and sustained a fracture in her right forearm. She was treated by physicians, but it was imperfectly aligned. The plaintiff claimed that the alignment resulted in somewhat limited capacity for arm movement, but she admitted on cross-examination that her ability to flex her arm was practically normal, if not entirely so. Her only real argument for negligence was based on the lack of alignment revealed in the X-ray. The defendant tried to argue that achieving imperfect alignments in fractures of the sort that she had was extremely difficult and, in fact, almost impossible. But the jury nonetheless found for the plaintiff, and though the appellate court reduced the amount of damages roughly in half, it sustained the verdict. Though alignment never became the sole definition of an adequate cure, there is little doubt that the availability of the X-ray image did create a new focus, not only on the function of a limb, but also on the aesthetics of the cure as revealed by the X-ray. As their anxiety about the legal use of the X-ray grew, physicians and surgeons began to argue that the X-ray image was not, in fact, as certain as it seemed. Both medical and legal journals worried about how to compare clinical judgment, or more broadly eyewitness knowledge, to the tracings of a machine and the evidence of instruments. Even those doctors who routinely used X-rays for diagnostic purposes feared that in the theater of proof, its seeming objectivity would give the X-ray too much influence. They thought it would unjustifiably trump softer testimony, even when that other testimony came from experts, and even when, in their view, the expert should have more authority than the image. Thus, they argued first that X-rays could easily be misread and misinterpreted, and that second, that they should be properly conceived of as a diagnostic supplement rather than a substitute for expert clinical judgment. These physicians wanted X-rays to remain within their control, to be understood as a supplement and never a substitute. To harken back to the theme, it was a battle between word and image. They wanted the images to shore up their words, but they argued for the ultimate primacy of their expert words over the apparent speak-for-itself quality of the image. As early as 1897, the American Surgical Association established a committee to study the medico-legal relations of the X-ray, and they concluded in 1900, in a thing which purports to be a representation analogous to a photograph, showing only what exists and nothing else, the claim of infallibility, of exact accuracy, is sure to be made by some lawyers and listened to approvingly by some judges and juries. But the time for such an attitude has not arrived, they said. They emphasized the degree to which X-rays could be distorted, exaggerated, and inaccurate, and collected large quantities of anecdotal evidence regarding incidents in which X-rays had been misleading. They emphasized, for example, how easy it was to take a distorted image using an X-ray. One of the qualities of an X-ray is its semi-legibility to lay people. It could create dramatic images which even lay people could often interpret. This was one early image, and you can see the little dots showing buckshot in the patient's hand. It's not difficult to interpret. And yet interpretation was not always so transparent. It was an unusual cultural object in this sense, semi-legible by lay people and yet in need of expert interpretations. Plaintiffs could, and allegedly had, shown juries distorted X-rays in which a deformity appeared far worse than it actually was. Altering the position of the X-ray tube in relation to the body could dramatically change the appearance of the fracture. For example, you can see that here. Or normal joint lines could be mistaken for fractures by the unwary. As a consequence of the many pitfalls of X-ray manufacture and interpretation, physicians emphasized that X-rays shouldn't replace their clinical judgment, They said that though useful, it should never be viewed as the referee or the final arbiter in a legal dispute, and that their clinical judgment should always trump the mere appearance of an X-ray. And yet physicians worried that courts and juries deal with tangible things, and feared that their influence might be supplanted by the tangible reality of the X-ray. They tried to claim that X-rays were only one diagnostic tool among many, that they were the only ones who could properly interpret the X-ray, and they sometimes brought in physical models to supplement the X-ray and to kind of reclaim some of their own authority. As one surgeon wrote, neither lawyer nor photographer, but only a professional man can estimate the relationship that the skiographic appearances bear to the clinical result produced by the treatment. That was in 1902. When they emphasized their clinical judgment and the limits of the X-ray, they were claiming that their testimony offered a better form of proof than the seemingly unmediated tracings of a machine. Only physicians and surgeons, they argued, should be allowed to speak for the X-ray. Judges were largely persuaded by this argument. Most judges, like most surgeons and physicians, thought that lay people lacked sufficient knowledge to interpret X-rays, and therefore allowed and usually required experts to testify as to the content of the X-ray and evidence. There were occasional cases that let the X-ray speak for itself and require no expert evidence alongside it, but that position was quite clearly the anomalous one. This was a partial victory for the surgeons and physicians. X-rays were not allowed into evidence without an expert to help interpret their meaning. By contrast, handwriting samples, introduced for the purpose of comparison with a disputed document, could be displayed directly to the jury even without the help of an expert. By persuading courts that an X-ray required expert interpretation, surgeons and physicians were thus assured that whenever the jury saw an X-ray image, a member of their profession would also have a voice in the courtroom. The image would be permitted, but only accompanied by the expert's words. The victory, however, was incomplete, for while judges generally insisted that an expert interpret the X-ray, they also typically required that if an expert spoke of an X-ray, the X-ray itself had to be brought into evidence. They therefore required both the interpretation and the tangible thing, both the word and the image. As a practical matter, this guaranteed that juries would not merely hear the diagnostician's X-ray-derived conclusions, but would also gaze upon the X-ray images firsthand. Interpreting experts were therefore by necessity teaching the jury how to read an X-ray. They needed to educate the jury to see the X-ray in the same way they saw it. The jury, however, did not need to accept the expert's interpretation. If it chose, it was free to read the X-ray for itself, to interpret the image in a different manner from that proposed by the experts. In other words, both the expert and the jury were authorized readers of the visual evidence. Although the expert's reading was privileged within the courtroom, it was, of course, the jury who would get the last word. This is an example of a more general phenomenon, I think, how the dynamics of the courtroom encourage experts to frame their knowledge in a publicly accessible way, to create ways of presenting science for the masses. By requiring that X-rays could be used only with interpreters, but allowing interpreters of X-rays only to testify when accompanied by the X-ray itself, judges guaranteed that a set of practical tensions between scientific evidence and softer clinical judgment, between jurors and experts as X-ray interpreters, between deference and authority, between image and interpretation, would be played out in the courtroom over and over again. Judges made these tensions into practical local concerns to be managed on a case-by-case basis, rather than resolved as a matter of law. I'm going to turn for just a few minutes now to the X-ray's epistemological status in the courtroom. What kind of evidence did the X-ray provide, and on what basis was it deemed admissible? In order to use any documentary or non-testimonial evidence in the turn-of-the-century American courtroom, anything from a map to a photograph to even a contract, the evidence had first to be authenticated or verified. At its most abstract level, authentication required, as the name suggests, offering evidence that would suggest that the document in question was authentic. In the case of representational evidence, evidence such as diagrams and photographs, evidence that illustrated the way something looked, authentication required that someone testify based on personal first-hand knowledge that the image was indeed an accurate representation of whatever it depicted. The admission of the image was predicated on the testimony of a person who could attest to the image's accuracy because he had seen the scene depicted with his or her own eyes. The X-ray therefore posed a dilemma for the judges. How could anyone testify based on first-hand knowledge that the X-ray image accurately represented that which it depicted? The value of the X-ray was that it could penetrate beneath the surface and make visible what otherwise remained hidden to the eye. Whose eyes, then, could authenticate the image? Moreover, the X-ray challenged the basic theory of visual evidence in the courtroom at that time. Until the advent of the X-ray, visual evidence, whether diagrams, photographs, or drawings, was not seen to be independent evidence in and of itself. It was understood instead as the testimony of a person in visual rather than verbal form. This is how John Henry Wigmore, the leading evidence scholar of the early 20th century, described the doctrine in his evidence treatise. A document purporting to be a map, picture, or diagram is for evidential purposes simply nothing, except so far as it has a human being's credit to support it. It is mere waste paper, a testimonial nonentity. It speaks to us no more than a stock or stone. We must somehow put a testimonial human being behind it, as it were, before it can be treated as having any testimonial standing in court. It is somebody's testimony, wrote Wigmore, or it is nothing. The theory of these forms of evidence was that they represented a witness's testimony rendered visually. It was a nonverbal mode of expressing a witness's testimony. Under this theory, the knowledge had to precede the image. The witness had to use the image to show the jury what the witness already knew. The knowledge was not supposed to derive from the image itself. To make the point more clearly, imagine a plaintiff wanted to show the jury a picture of an accident site. The witness couldn't testify, this is what the site looked like, and I know that because this is the way it looks in the photograph. That reasoning would be circular, and up until the point of the X-ray, not permitted. And yet in the case of the X-ray, independent knowledge of what the X-ray illustrated generally didn't exist. The thrill of the new technology was that it brought to light that which had been invisible. It revealed things previously unseen. This, then, was the puzzle that judges faced. The admissibility of images into the courtroom required authentication. Authentication required eyewitness verification of accuracy. And in the case of the X-ray, independent eyewitness verification was not feasible. Instead of merely illustrating what a witness had seen, the X-ray was the source of the witness's knowledge. If, as Wigmore suggested, a visual representation had to illustrate someone's testimony or be mere waste paper, by the established doctrines regarding the admissibility of nonverbal evidence, X-ray evidence properly belonged in the garbage bin. And indeed, some judges, though just a few, did reject X-ray evidence on the grounds that the picture was not an exact representation and could not be verified. One judge rejected the X-ray because he found the whole notion too implausible. He wrote, "There's no proof that such a thing is possible. It's like offering the photograph of a ghost when there's no proof there's any such thing as a ghost," he said. Other judges, too, expressed skepticism, noting that no man can tell by ocular or other sensory evidence that the reproduction is accurate. Like spirit photographs of ghosts, X-rays were shadows that couldn't be verified by the ordinary, unaided human eye. But as I've already suggested, this reluctance was not the only reaction or even the dominant one. Rather, other judges began allowing X-rays into evidence within mere months of their discovery. They did this taking three approaches. Some simply made reference to science and the greatness of science. As one judge put it excitedly, the court must throw open the door to all well-considered scientific discoveries, and kind of left it at that and ignored these problems of authentication. Other judges simply admitted it as a subspecies of photograph and just ignored the fact that X-ray images couldn't easily be shoehorned into the rule governing the admission of photographs, as the justification didn't quite apply. But there was a third method, more carefully reasoned than either of the previous approaches, that came to dominate judicial reactions to X-ray evidence. This was to decouple verification from eyewitness observation. Prior to the X-ray, verification meant verification through eyewitness knowledge. But with the X-ray, some judges began to approach the question of authentication more abstractly. Perhaps an eyewitness's personal knowledge was not the only way to authenticate an image. Perhaps instead judges could simply require testimony showing that the process produced reliable images and that this particular image had been reliably made by a skillful and proficient operator. In other words, they continued to maintain that verification was necessary, but they expanded the possible methods by which verification could be achieved. No witness could testify that he'd seen the bone stripped of flesh, but a witness could testify that the X-ray process was thought to be reliable, that this X-ray machine in particular was properly functioning, and that it was operated by somebody with the requisite skill. Instead of verifying the image, witnesses would authenticate the process. The dynamics of the common law can encourage judges sometimes to resist change and sometimes to understate it. And few judges who took this third approach commented extensively on this new way of authenticating images. And when they did comment, they treated it as a relatively natural extension of what had come before. Wigmore gave it a little more attention. He wrote, "It's obvious that in using certain mechanical instruments based upon the science of physics, we obtain a representation of things not perceivable by the ordinary senses. Upon the principles of testimonial knowledge, can it be said that we have personal knowledge? Our impression is not received by the unaided senses, but depends for verity upon the correctness of the intermediate instrument or process. It is as if our senses had been abnormally enlarged in scope or capacity. And we may here also claim to have knowledge," he wrote, "in the ordinary sense, provided that the instrument or process is known to be a trustworthy one." Unlike some judges then, Wigmore did explicitly acknowledge that verification of the X-ray was quite different from authentication of ordinary photographs, and that it depended on process rather than simply the accuracy of the depiction. But I think even Wigmore didn't fully face the significance of this shift. In Wigmore's taxonomy, the X-ray is like a pair of spectacles. It improves our vision. Wigmore's label for processes like the X-ray as sense expanding understates, I think, the novelty of this evidentiary shift. For what we actually see in the case of the X-ray is something rather dramatic, a shift from the authority of the eye to the possible authority of the machine. Until the X-ray was used as evidence, the exclusive way to authenticate visual evidence was on the basis of eyewitness testimony. Visual forms of proof were allowed only when some human being testified that the image accurately depicted that which he or she had seen with his or her very own eyes. The human eye was the legitimator of the evidence. Even the photograph, mechanically generated though it was, had to be authorized as evidence by an eyewitness. But with the X-ray, for the first time, evidence doctrine explicitly allowed admissibility to be grounded upon the trustworthiness of a process and the dependability of a machine. Judges for the first time placed the authority of a machine on a par with the authority of the eye. This marked, I think, a significant theoretical victory for ostensive evidence, the first time that a reliability of a technological process was itself the justification for admissibility. We can see in this examination of X-ray evidence in the courtroom the creation and institutionalization of two approaches that continue to characterize the approach to scientific evidence that we see even today. First, X-rays reveal an illustration of the tension between the expert and the expert's visual inscription. Surgeons and physicians wanted to use the visual image to shore up their authority, but they were concerned that the X-ray not supplant their clinical expertise. While recognizing its diagnostic utility and the possibility for shoring up their legitimation before the jury, they still wanted to keep it within their control and subject to their interpretation. But they were not the only authorized readers of the X-ray in court. Rather, the lay jury was also allowed to see the image and interpret it for itself. And this approach to X-rays encouraged physicians and surgeons to become educators when they testify, to learn to teach and translate, rather than merely to pronounce their opinions and judgments. As it became a commonplace form of legal evidence, the X-ray brought to light a number of tensions surrounding the use of expert evidence, tensions that still remain with us today. Were experts supposed to teach lay jurors to read the technological evidence for themselves? Or were better outcomes likely if jurors just deferred to the expert's authority? Whose eyes would properly interpret the X-rays? Which evidence counted more, the clinical judgment or the objective fact of the X-ray plate? Physicians argued that their clinical judgment should supersede the lay interpretation, but the judicial response made this attention to be managed within each trial rather than a matter of legal doctrine. While the approach developed to determining the admissibility of X-rays didn't resolve the issues, the rise of the X-ray evidence brought these tensions to light, even as it brought into sight those fractures, bullets, and misaligned bones that had previously remained buried and invisible in the patient's body. Perhaps even more significant, it was with the X-ray that judges first based admissibility on the legitimacy of a technological process. It was the first time that the reliability of such a process was the explicit basis for admitting evidence. To be sure, the X-ray was still not entirely self-proving. A human being did still have to testify that the particular X-ray was made by somebody qualified to do so and that the machine was working properly. But as a mode of proof, it was allowed to be more self-evident than any prior form of proof had been permitted to be. It was officially declared to be a mechanism for producing accurate and true depictions, and some courts even took judicial notice of this fact. Today, I've given you just one piece of a broader story of what I think was an important epistemic shift, an increasing, if ambivalent, desire for forms of evidence that seemed to be less mediated, that promised to speak directly to the senses of the fact finder, and that offered the potential for more certainty than the lay eyewitness. This epistemic shift was certainly partial and often reluctant, but I think there's little doubt that over the course of the second half of the 19th century and the first decades of the 20th, effective legal proof grew to be thought of as ever more connected to effective scientific knowledge. This was, to be sure, just the beginning of this transformation. In the early part of the 20th century, the progressive penchant for expertise, the rise of the crime detection laboratory, entrenched science and expertise ever more firmly within legal culture. The significance of scientific forms of proof continues to grow. DNA profiling is the latest form of ostensive proof to promise a certainty that can transcend human judgment. Most of these 20th century forensic technologies also have a strong visual component. They offer methods for identifying traces, objects, and people, and displaying these identifications in visual form. The rise of these 20th century forensic technologies further substantiates the strong connection between many forms of expert evidence and the use of visual and demonstrative proof, and also suggests that the trial process structurally encourages scientists to develop techniques of visual display and to locate their expert knowledge partly within these inscriptions. In conclusion, though, I want to suggest that we must guard against reading this story as a simple progress narrative. That is, a story of science invents and law responds, eagerly beckoning into its ambit the new forms of proof. Nor do I mean to suggest that scientific invention operates as a prime mover, with the legal system simply accepting its latest offerings. The dynamic, I think, is rather more complicated. In the courtroom, science and scientists have little choice but to have a public face. Experts succeed in the legal setting only to the extent that they create a publicly accessible science, a way of representing their knowledge and themselves that is sensible and comprehensible to the lay populace. The courtroom thus pressures experts to create allies for themselves in the forms of visual and demonstrative methods of proof that can seem almost indisputable or authoritative, rhetorical spectacles that can seem almost to speak for themselves. The dynamics of the trial also encourage concrete manifestations of knowledge and prowess, rewarding elaborate feats of display rather than hidden preserves of knowledge. Trials always can threaten to put scientists and their methods on trial as well, and sometimes the best way to persuade a jury is to dazzle them and make them believe that they understand what the scientist is saying and doing. Thus, it's possible that the courtroom certainly affected the public face of science, the way in which scientists were understood, their chosen forms and modes of self-presentation. More arguable, I think, is the question of whether the courtroom affected not just this public understanding, but the actual practices of science as well. Especially in an adversary system in which cross-examination endeavors to explore those hidden crevices and potential counterarguments, a distinction between the public face of science and the actual practices of scientists, I don't think, can hold. Therefore, for those interested in the history of objectivity, cultural conceptions of proof, and popular epistemological understandings, the courtroom, I think, is quite an interesting site. It's a key cultural location within which claims to epistemological authority can be legitimated and challenged. I think, therefore, it should be recognized not merely as a place that receives outside wisdom, but as a space in which narratives of scientific knowledge may also be born and developed. Thank you.